copies.
I'd like to.
Could I finish, please? I'm not being rude, please.
I only have 5 minutes.
No, yeah, and I only have 30 seconds based on your filibustering.
Well, you didn't give a yes or no answer.
A House Judiciary Committee hearing erupted into a heated confrontation when Representative Zoe Lofgren questioned Attorney General Pam Bondi about emails connected to Jeffrey Epstein and whether they justified further investigation. What began as a straightforward question quickly expanded into a broader debate over transparency, redacted records, and public trust in the Department of Justice. Watch the exchange first, then we'll break down what was said, what wasn't said, and why this hearing is generating so much attention.
I want to briefly direct your attention to 2 documents I'm hoping we will put up on the screen. In the first, an individual emails Jeffrey Epstein asking whether a woman identified as M was pro or civilian, and Epstein responds that she was a civilian, Russian, and fun. In the second email, Epstein writes to Steve Tisch about a Ukrainian girl, noting that she was, quote, a little freaked out by the age difference and stating that he would try to convince her not to return to Ukraine. He then instructs Mr. Tisch to call him, adding, I don't like records of these conversations. So I'd like to ask a straightforward question that really is either a yes or no answer. Do these emails constitute credible evidence, not proof, but credible evidence warning further investigation into whether Steve Tisch was involved in Epstein's criminal conduct? Do you think yes or no?
I'm not going to play a yes-no game with you, but I will answer the question to the best of my ability. As I said, we will look and investigate any case involving any victim. I'm not familiar, there were 3 million pages, of course, with that email, but of course, we will look into anything. The documents have been released, 3 million. The redacted versions, we left them open for all of you to come view. I believe you view them. If not, will you have some copies?
I'd like to.
Could I finish, please? I'm not being rude, please.
I only have 5 minutes.
No, yeah, and I only have 30 seconds based on your filibustering.
Well, you didn't give a yes or no answer, so let me just go further. Director Patel testified in this committee room that there was no credible information indicating that Epstein trafficked victims to anyone else. And glancing at the documents, that proves that's not the case. In July, your department issued a memo stating that it had conducted an exhaustive review of the Epstein files and concluded that no additional individuals would be charged. So I did go over to the Department of Justice yesterday. I would note that 400 and all our 35 members are in the House, and there's 4 computers. So it would take many months to actually have the time. I only had a few hours. I think the transparency argument is really kind of a sham because it's not really possible.
Whoa. Did you have to wait to get a computer?
It is not possible to really go in. I did, however, see a U.S. attorney information for the Southern District of New York indicating that there were additional survivors and probable co-conspirators. Other members of Congress have uncovered likely co-conspirators whose names were blocked out. Now, the Epstein Files Transparency Act, which all but one member of this House voted for and the president signed, requires the department to release everything except that it needs to be redacted to protect the victims or an ongoing prosecution, which apparently there is none from the testimony we have received. I am concerned that this act has not been fully complied with. When Director Patel came to the committee, he admitted that up to 1,000 FBI agents had gone through the files and redacted President Trump's name from them. And it's pretty clear that what has been transmitted from the FBI continues to redact President Trump's name, even though he is mentioned thousands of times in these files. So I think the credibility of the department in terms of complying with the act has been damaged. And I think the department's credibility has been damaged in other ways. I think we all saw the horrible video of American citizens being killed by ICE agents in Minneapolis. And I think how the department has handled these cases raises a lot of doubt about the department. State and local police in Minnesota got a court order to get access to the crime scene to be sure evidence would be properly preserved by federal agents. But they took the agents defied the court order, and in a departure from general policy, the DOJ is not collaborating with state and local law enforcement on these homicides. So I really think that is a disgraceful approach to the homicides of American citizens, and really does nothing to bring credit to your department. And
I find it interesting that she keeps going after President Trump, the greatest president in American history. And if they could maintain their composure, this isn't a circus, this is a hearing. I find it interesting she keeps going after Donald Trump. She doesn't say how much money she took from Reid Hoffman, did you? None. And nor did
Mr.
she
Chairman,
post
regular
anything.
order, please.
She
Regular
posted
order.
nothing on her X account, on her Twitter account during the Biden years.
Gentlelady.
And yet now,
there
all
was
of
no
a sudden,
question
she's
asked.
going after
Committee will be in
order. There was no question
Shame on
asked
you.
the Attorney General. She doesn't just get to speak.
Committee will be in order.
I have a point of order, Mr. Chairman.
Committee will be in order.
Point of order, Mr. Chairman.
Gentlelady can state her point of order.
When a witness attacks,
Not a valid point of order. You got to state.
She hasn't completed her point of order yet.
Gotta
Please let her
cite.
speak, Mr. Chairman. Let's have some regular order here.
Regular order is you got to state the rule. And she
I am
didn't do it.
trying to make a point of order that the witness,
And what rule are you referring to?
without responding to a question, has attacked me personally. I think it's pathetic that she can't answer the questions and
First
instead
time
is
that
attacking
is not even close
members
to a
of the
point of
committee.
order.
What you just watched was not simply a disagreement over a single email. It was a clash over transparency, accountability, and public trust in one of the most scrutinized criminal investigations in modern American history. Representative Zoe Lofgren entered this hearing with a very specific objective. She was not attempting to prove that anyone had committed a crime during her questioning. Instead, she focused on a narrower issue. She wanted to know whether certain emails connected to Jeffrey Epstein could reasonably justify further investigation. That distinction is important. In the legal system, evidence that justifies additional investigation is not the same thing as evidence that proves guilt. Investigators routinely examine leads, communications, witness statements, and other materials to determine whether additional facts exist. The purpose of an investigation is often to answer unanswered questions. Lofgren repeatedly emphasized that point. Her question was not whether Steve Tisch should be charged with a crime. Her question was whether the communications she cited met the threshold for additional scrutiny. Attorney General Pam Bondi chose not to answer in a direct yes or no format. Instead, she emphasized that the Department of Justice reviews allegations involving victims and that investigators have examined an enormous volume of material connected to the Epstein case. Supporters of Bondi would likely argue that public officials should avoid characterizing individual pieces of evidence in a highly sensitive matter. From that perspective, reducing a complicated legal issue to a simple yes or no answer could create misunderstandings about guilt, innocence, or the status of any review. Critics, however, see the exchange differently. For critics, the absence of a direct answer reinforces a concern that has existed for years. They argue that the public continues to receive broad assurances that investigations have been thorough, while receiving relatively few specific explanations regarding how certain conclusions were reached. That disagreement sits at the center of the hearing. One side is essentially asking the public to trust the review process. The other side is asking for greater visibility into how that process works. As the hearing continued, the discussion expanded beyond the emails themselves and moved into a broader debate over access to the Epstein files. Lofgren argued that practical access to the records remains limited. Her criticism was not simply about whether documents exist. It was about whether lawmakers and the public can meaningfully review the information that has been released. This raises a question that appears in many government transparency disputes. Is information truly transparent if it is technically available but extremely difficult to review? Government agencies often point to document releases as evidence of openness. Critics frequently respond that the volume, complexity, or format of those releases makes meaningful examination challenging. The Epstein Files have become one of the most prominent examples of that debate. Years after Epstein's death, public interest remains intense because many people believe unanswered questions still exist regarding the broader network surrounding him. The hearing also touched on another issue that repeatedly surfaces in discussions of the Epstein case: redactions. Redactions are common in legal and investigative records. Names and information may be withheld for a variety of reasons, including privacy concerns, protection of victims, witness safety, or legal considerations. However, in a case that has generated enormous public attention, redactions often become controversial. Supporters view them as necessary safeguards. Critics view them as obstacles to transparency. That difference in perspective was visible throughout the hearing. Lofgren argued that public confidence in the process has been weakened. The department's position, meanwhile, is that reviews have been conducted and decisions have been made based on evidence and legal standards. The challenge is that trust is difficult to restore once doubts emerge. For many Americans, the Epstein case has become larger than the crimes of one individual. It has become a symbol of a broader concern about whether powerful people receive different treatment than ordinary citizens. That concern helps explain why hearings like this attract significant attention. Viewers are not only evaluating the answers that officials provide, they are also evaluating how those answers are delivered. Body language, tone, willingness to answer directly, and the ability to explain decisions all shape public perceptions. During this exchange, Lofgren attempted to keep the focus on a narrow investigative question. Bondi attempted to place the issue within the larger context of a massive review process. Neither side appeared satisfied with the other's response. As a result, the hearing increasingly shifted from discussing evidence to discussing credibility. That shift may ultimately be the most important part of what happened. The debate was no longer simply about specific emails. It became a debate about whether government institutions have earned public confidence in the handling of one of the most controversial cases in recent memory. Regardless of political affiliation, viewers can observe two competing perspectives. One perspective argues that investigators have already reviewed the evidence and reached conclusions through established legal processes. The other perspective argues that unresolved questions and continuing public skepticism justify additional scrutiny and greater transparency. The hearing did not resolve that disagreement. If anything, it demonstrated why the controversy continues. Years after Jeffrey Epstein's death, lawmakers are still debating access to records, the scope of investigations, and whether all relevant questions have been answered. That ongoing debate explains why exchanges like this continue to generate attention inside Congress and beyond. For supporters of greater transparency, the hearing reinforced concerns that important questions remain unresolved. For those who trust the investigative process, the hearing demonstrated the difficulty of addressing highly charged allegations through public testimony alone. Either way, the exchange highlighted a reality that continues to shape discussion surrounding the Epstein case. Public confidence depends not only on the outcome of investigations, but also on whether people believe the process has been transparent, thorough, and accountable. And that is why this hearing continues to resonate long after the gavel came down.